Medicare is a national social insurance program. It's for those 65 or older, or those that qualify with a disability under the program. Some disabilities include end-stage renal disease and ALS, or Lou Gehrig's disease. To qualify for the program, you must have worked, paid into the program, and be over 65 or qualify under one of those disabilities. The Medicaid program, or called medical assistance in Minnesota, is a joint state-federal program that provides social health care. In order to qualify for medical assistance, it's a means-based test, so you have to have low income or qualify and be receiving supplemental Social Security income. That's a great question. No, not necessarily. Under Minnesota Statute 149A.91, Subdivision 3, embalming is only required in certain circumstances. For instance, if you're going to be shipped across state lines or to another country via common carrier, you have to be embalmed. If you're going to have a public viewing in a place like a funeral home, you have to be embalmed. If you are considered an infectious disease case by the Commissioner of Health, it may be required in that instance as well. Embalming is not required if final disposition takes place within 3 days or 72 hours after the death. This is generally counted any time that you're at a medical examiner. If there's an accident, it would be after that time. If you are going to be held for longer than 3 days, either refrigeration or embalming are required. There is a new statute as of a few years ago that if you are going to have a private viewing in a house, not a funeral home, you may have an open casket and put the body on dry ice, where embalming is not required. With the age of green funerals and people being more eco-conscious, that's an option that's available for people who don't want to be embalmed. Life care planning is a holistic approach to elder law. And I say elder law specifically because really what you're dealing with are people who are over the age of 18 who have mental or physical infirmities. That's basically what we deal with in elder law. Life care planning takes that client from wherever they start with us, whether it's a disabled young adult or somebody retirement age who's looking at long-term care planning, and we take them through that process, help them with estate planning documents, if there's guardianship or conservatorship involved, any litigation that may arise, and we take them through that process. Life care planning doesn't end when the life ends. Our firm also does probate. Elder law, you get families. We deal with the families from when the client is maybe in their 50s or younger, follow them through to death, and then help the family resolve any conflict after the death occurs. So life care planning is the whole shebang. Both are trusts created for the benefit of a beneficiary who will or has been receiving government benefits. The purpose of both of them is to allow supplemental income coming in on top of what the government is providing, whether it's for healthcare or living. The main differences are a special needs trust is created by the person, the client, the beneficiary. It's for their benefit, and upon their death, if they've received any sort of government benefits, the government will be paid back by way of, say, a medical assistance claim. A supplemental needs trust is created by a third party for the benefit of the beneficiary. Usually it's done through inter vivos creation by parents, for instance, or a testamentary document for a child. The supplemental needs trust does not list the state as a beneficiary and does not require payback of any claim for the beneficiary. It is irrevocable, both are, and are not attached to any sort of benefits. In other words, they are irrevocable for government assistance benefits.